defending personal property. When can you defend your personal property? Your computer, your phone, your car, things like this. We'd like to give criminal defense attorneys perspective on that in the state of Washington, starting, I suppose, with that it's driven by a revised Code of Washington 9A.16.020, which also happens to be the statute that allows you to defend yourself.
Yeah, the thing about this affirmative defense, as we've said before, affirmative defenses are great from the perspective of they can justify what you're doing and you get a pass, so to speak, on it. But when you want to use one of these, you're already admitting to the fact that the underlying assault occurred, and what you're saying is, I was justified in doing this. And in so saying, you have to prove two things. One, that the item that you're trying to retain is lawfully yours. And two, that the force you used was no more than justified under the circumstances.
Yeah, and that gets it has to be reasonable force. That's the tricky argument, and you and I are diametrically opposed.
We're
in this
definitely
defense.
diametrically opposed on this one.
You don't like you don't like the defense of property cases.
No.
As a generality, and I am more inclined to agree with people that use of force is okay to defend personal property. You are not, and it's an interesting. We're like a jury in and of ourselves.
Well, the problem you've got is, I look at it from the standpoint of, especially if you're looking at especially technology, your cell phones, your computers, even your cars. You know what? 6 months down the road, all those products get modified, they get better, they get a little bit cheaper. You've got more options. So if she wants the computer, she wants the cell phone, or he, let him have it. And then what we can do is get the cops involved and say, hey, go get me my stuff. If they're like, oh, she says she doesn't have it or he doesn't have it, that's fine. Well, I've got a sales receipt. I can go on my credit card and say, boom, they took it, it's not here. Get it back for me. Or we can argue about that when we hit court.
Yeah, and lawful possession it's a very interesting issue as it relates to personal relationships, close personal relationships, commonly called domestic violence in the criminal system. Whether or not your ex-wife or your ex-husband or your roommate or your child is able to destroy a piece of property in front of you, it starts becoming the question, whose really is it? Did the kids destroying a piece of property you bought, it's kind of your personal property. When you buy the piece of personal property out of a joint checking account and you guys have been married 20 years, is that really your personal property, or is it our personal property that she has a right to destroy some of? And I've had some very interesting discussions with prosecutors about that topic, and about whether or not that allows, under what circumstances can I claim a defense of property case. But at the root of it, I tend to agree with you. I don't want to be in court arguing about it if I have a disagreement with my roommate, or with my, I got divorced and I got a major blowout with my wife and something terrible happened. I don't want to be arguing about it with court. But I think fundamentally, I tend to, if I'm on a jury of people like me, I think you're more likely to have someone say it was okay to use force to defend your personal property. And I'm probably pretty soft on even how much force you're allowed to use and whether that was too much force. You, on the other hand, 6 of you, I'd be hosed.
6 of me, you wouldn't be able to get the defense.
Yeah. Or you wouldn't support it.
I wouldn't support it, because I think that property is a whole different ballgame. You're not defending a person, you're not defending a life. You're basically going after something that can be repurchased.
Yeah, and I think that's just a microcosm of the issues surrounding jury trials in general, of when you're bringing self-defense cases. Both of us can argue anything. Both of us will argue anything in front of a jury to the fullest extent we're capable of doing, but you how to realize that you're asking other people to agree with you, 6 people or 12 people to agree to what you're saying. And a affirmative defense is, interestingly enough, you have to prove by preponderance of the evidence, which is more than 50% from my perspective, just more than 50%. You have to prove that your defense is there, that the property was yours, that the force was reasonable, that you admitted to the assault, but you had a reason to do it, you were defending your personal property. Once you get past that preponderance, the evidence standard, the burden shifts to the prosecutor.
Right.
And then the prosecutor has to prove beyond a reasonable doubt that what you're claiming is not true.
Correct. But once again, and this goes back to our fundamental dispute in this area, I don't think it's worth it. I mean, if you're in a position where you've got a claim like this, come in, talk to us, we'll run through things. He'll give you his perspective. I'll give you my perspective, and you can make the call as far as how you'd like to proceed.
And I think it's worth defending your personal property, but don't end up with a criminal charge out of it.
Exactly.
And so it's a lot of it has to do with whether or not how much control you have when you're deciding to hold on to something, how much force you use. You once said to me, you know, when someone tries to take my laptop out of my hand, and in the process of pulling it out, I smash them over the head with it by accident. I can't even argue that in good faith. But I hit somebody with it and I break their ocular. I just got myself charged with a crime because my force was not.
An assault too is what you got.
And will that get in front of a jury?
We'll see.
Yeah, that's the problem. Will a particular judge in that circumstances be more my direction than your direction, and will the jury be more in your direction than my direction? These are very touchy cases. But you should talk in detail about the facts. You got to have a lawyer that does, and you have to have a lawyer that goes and does the investigation on it. We do recorded interviews of our potential witnesses and related to cases for this very reason. You really got to hammer out what you're going to try to put before a jury before you make the calculated decision to run to a jury trial.
Right. Call us.
Call someone.